case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re FR and AR Juveniles, case number 24AP307. Representing the appellant mother is attorney Sarah Starr. Appellant father, represented by Sharon Gentry, is not present for oral argument. Representing the appellee, the state of Vermont, is Julianne Woolard.
Thanks very much. Good morning, everybody. Counsel for the appellants, are you dividing up your time?
No, Your Honor.
Are both lawyers here? Maybe I misunderstood.
I'm only representing the mother, and I was the only one that requested argument.
I see. So is attorney Gentry here?
No.
No, I get it. Okay. So Attorney Starr, please introduce yourself for the record, identify your client, and then proceed.
Thank you, Your Honor. I'm Sarah Starr, and I represent the appellant mother, TR.
Thank you.
The termination of parental rights should be reversed because the appellant overcame incredible obstacles in this case to work with DCF to care for her young children. Looking at this case from start to finish and examining each parent individually, there was no basis for a stagnation finding regarding the mother. Mother had a history with DCF, but starting when she was just 17 weeks pregnant, DCF intervened and opened a case to assess, quote, the safety of her pregnancy. The department was clear that it was investigating both her pregnancy and the home, but the only steps that the department took were to talk to TR's medical providers behind her back after she explicitly told DCF that she did not consent to the investigation of her fetuses. So despite no illegal drug use, DCF continued to talk to TR's medical providers surreptitiously throughout her entire pregnancy in violation of her express wishes and without releases. So then when the twins were born, months into DCF's case, the mother immediately began to work with DCF.
The children went into custody the day they were born, correct, Ms. Starr?
That is correct. Yes,
And
the state was
with both medical issues as well as drug issues.
There were no drug issues. At first, they thought that there were, but there were not. That was never proved. And then after that, months of litigation ensued on the merits of the case, which was solely the issues were what the state was trying to hold the mother responsible for her children's birth outcomes because they were small and one of them had some issues with their feet. And so really the state spent a year trying to hold this mother accountable for her pregnancy, despite no illegal substance use that was ever proven. So, but when mother was actually parenting live children, she was able to reunify with the children, and then DCF discontinued services, not because of anything that the mother did, but because of the father's conduct. And then when the mother got the children back again, she did it was because the father did what he needed to do finally. But then she had another baby and had trouble caring for all of these children with some complex medical needs while being blamed by DCF for those medical needs and was terrified of losing custody over medical issues, including ear infections.
Yes. Wasn't one of the issues, though, not solely related to father, the issue with I believe it was an ear infection and failing to treat that ear infection?
Absolutely, but an ear infection is woefully insufficient for terminating parental rights. And on balance, the evidence was just insufficient. The case, and especially looking at, termination of parental rights over a failure, an inability to treat chronic recurring ear infections that were a problem even in foster care, It just shows how DCF weaponizes medical care, creating an environment of fear and retribution among Vermont's pregnant and parenting population, sowing doubt and distrust between medical providers and the state and the parents.
You have 1 minute.
Okay. In this case, it's a pattern that continued throughout the case where DCF didn't approve of the doctors that the parents chose and changed the children's medical providers and got different opinions. And so the mother was able to really persevere throughout this case, work with DCF, work constructively with DCF, and do what she needed to do, not 100% of the time. But as your honors have said, these cases aren't a checklist. You have to look at the life of the case, and the life of the case shows that this mother overcame huge insults to her personal autonomy and dignity to work with DCF for the benefit of her children, and her parental rights should not have been terminated. Thank you.
Okay, thank you very much. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. My name is Julianne Woolard. I'm here for the state. May it please the court.
Thank you.
Your Honor, you should affirm the lower court's holding terminating both parents' rights in this case. This case is not about issues that predated merits, about issues that may have been present during mother's pregnancy. Mother did not raise those issues. She did not appeal the merits order, and that became a final order post-disposition in the fall of 2021. Contrary to mother's arguments on appeal, which essentially amount to her disagreement with the court's assessment, there's no reason for this court to reverse the termination order. The state presents primarily responding to mother's arguments regarding her characterization of the court's stagnation assessment. The state's argument is mother's characterization is just wrong. The court properly used the guideposts identified through the disposition case plan in assessing whether or not mother had made the changes contemplated at the time of both the Chin's petition and the disposition case plan, which again became a final order in the fall of 2021. The risks identified involved chronic domestic violence in the household, which mother chose to reside and co-parent with the alleged abuser. And she chose that throughout the 4 years this case was pending. The court properly relied on the fact that she wasn't able to provide a safe household where she was understanding of the impact of domestic violence on her children. And the court properly considered that in its stagnation assessment. Similarly, regarding the medical needs of the children, they were identified in the disposition case plan. They were also identified in the initial case plan produced in 2020 during a period of time when either mother was on arrest warrant status or incarcerated. Mother did begin working with DCF, but it was once she had been released from prison. And I believe that again was close to the disposition in the fall of 2021. The court didn't commit any error in considering the kids' significant medical needs that were identified throughout the entire case and considering mother's inability to properly treat them as evidenced from 2022 on throughout the next 2 years of the Chin's case. It was not an isolated incident of the ear infection that the court used. There were other incidences in the record where mother was unable to meet the medical needs of the children. Providers were contacting DCF at the end of the 2022 trial reunification, and the same thing happened in 2023. And the court, again, was properly using the guideposts identified in the disposition case plan, the risks that all parties agreed to in that case plan, which became a final order. There was no error in the court's decision, and this court should affirm the termination decision. And unless there are any questions, the state will rest on its brief.
Okay, thank you very much. Does the appellant have time?
Appellant has 8 seconds remaining.
Counsel? You're muted. You're muted.
I would just note that DCF never requested or advised that mother should leave the household, and that mother cannot be held responsible for the failure to admit to conduct that was the father's. Thank you.
Okay, thank you. Thank you both. Please call the conclusion of the hearing.
Next hearing for the court